Welcome to the next edition of War Story Wednesdays. Today I want to talk a little bit about homeowners associations. One court of appeal has said that homeowner litigation in California is about as common as crabgrass. And I think that the court of appeal is right. This is a case that evolves around attorney's fees when it comes to homeowners litigation. There's a civil code section, I want to make sure I get it right, 5975. And according to Civil Code 5975, if there is a lawsuit with respect to homeowners association liability, awarding of fees is mandatory. It's not discretionary. And those fees go to the prevailing party. But how do you decide who the prevailing party is? In some instances, if you're suing for money and you get $1, you can be deemed the prevailing party and then be entitled to attorney's fees of $100,000, and it's happened. But in homeowners litigation, there have been instances where a homeowners association doesn't get a monetary award, or the homeowner doesn't get a monetary award. How do you decide who's the prevailing party then? It comes down to who obtained their litigation objective. What does that mean exactly if money is involved? In a recent case, a homeowner was sued by a homeowners association, and the homeowners association was claiming $50,000 in fines and fees and penalties, and 17 different violations of the CC&Rs, the covenants, conditions, and restrictions. And the homeowner said, "Oh, horsepucky," and they went to trial. And the homeowner won on all but 4 or 5 of those claims, and that $50,000 turned out to be a $6,000 award. In fact, there was only one claim that the homeowners association won, and it was a minor violation of some rule. So the homeowner said, "We're the prevailing party. We obtained our litigation objective of beating that $50,000 worth of fines down to 6. And the homeowners association said, "Well, no, we won because we got $6,000. That's more than $1, right?" And the Court of Appeal said, "You're both wrong, because it really doesn't have to do with money." The homeowners association was suing, the Court of Appeal said, to be able to establish that it had the right to impose rules. And the homeowner was trying to say, "We're exempt from those rules, let alone violating any of them." And once the homeowners association won the right to impose rules, it was deemed the prevailing party, and its fees were more than $100,000. Oh, no! Ouch. It's important to make sure that you distinguish between the mandatory fees under that section 5975 from, there's a different section, 5235. And 5235 is when a homeowner wants to get records from the homeowners association. If the homeowner is successful, it gets to collect its fees as well as its costs. The homeowners association, on the other hand, if it wins that battle about getting records, gets nothing but costs. No fees are awardable to it. Why? Why aren't they reciprocal? Because the legislator didn't write it to be reciprocal. Say thanks to your guys in Sacramento. Homeowners association law is complex, and there's all kinds of twists and turns. The Davis-Sterling Act is where most of that stuff is found. When you have a question, give us a call.